Hello, I'm Representative Roger Goodman, and in today's Good Minute, we'll talk about our efforts to create more just and effective paths for incarcerated young people to move toward rehabilitation and reentry into the community. A large body of research has established that a young person's neurological system is not fully developed until the age of 25. Over the last decade, Washington has worked to recognize that reality in its sentencing and incarceration practices. Adolescents and young adults, whom we often call emerging adults, are much more impulsive than full-grown adults and are unduly subject to negative peer influences. When these young adults, aged 18 to 25, run afoul of the law, they're considered less culpable for their crimes because they tend to think only in the short term and cannot assess the consequences of their actions. This does not mean that young adults should be excused for their behavior that harms others. However, the research shows that more remedial and rehabilitative responses to young adult crimes are much more effective in reducing their chances of reoffense. An overly harsh and punitive approach to young adult crimes is too often counterproductive, hardwiring the adolescent brain for fight or flight and perpetuating antisocial and criminal behavior. Recently, on Martin Luther King Day, the House Community Safety, Justice, and Reentry Committee, where I serve as chair, heard testimony from incarcerated youth who have been convicted of serious offenses. These young men and women reminded us of the need to continue our efforts to consider the brain science as we fashion appropriate responses to criminal offenses by youth. Before the legislative session, I worked with these students on legislation relating to sentences for people who commit their crime before the age of 25. Some of those students traveled to the Capitol in Olympia to testify on these important bills, which include House Bill 1325, allowing incarcerated people serving long sentences to seek a review of their sentence if the infraction was committed before the age of 25. House Bill 1383, giving youth who committed crimes before their 18th birthday to petition for early release if they can demonstrate their extraordinary rehabilitation and a very low likelihood of committing any new offenses. And House Bill 1396, which would bring our law into compliance with a Washington State Supreme Court ruling and concerns sentences for aggravated first-degree murder committed prior to the age of 21. We all want safe communities supported by a criminal legal system that reduces harm and reflects the latest science and provides just paths to reentry. It is vitally important that the criminal legal system reflect what we know about brain science and rulings by the state Supreme Court. And we must work toward a more just criminal legal system for youth in particular. Thanks so much for your interest and attention to this issue. As always, I look forward to hearing from you. Please don't hesitate to reach out to my office or testify in committee. And I'll be back with another Good Minute sometime soon.